Okay, welcome everybody to this webinar hosted by Walker Morris and Radius Consulting today on the subject of dilapidations and disrepair in commercial leases. Just a quick housekeeping point. I am Martin McKeague. I've had some difficulties with my webcam in setting up in the preamble to this session, so unfortunately my camera isn't working, but you will be able to see the other speakers today, but hopefully my audio is coming over loud and clear to everybody. So you'll be hearing today from myself and other members of the real estate litigation team at Walker Morris. I'm also delighted to say that we have Paul Raeburn of Radius Consulting with us, who is one of the leading authorities on the subject of valuation and dilapidations claims. And Paul brings to the table today over 25 years of experience in advising in this area. I think it's fair to say that the last 6 months or so have certainly been the most tumultuous and interesting in my time as a real estate litigator. I think trends in commercial property that we might have expected to play out over the next 10 or even 15 years have been condensed into the last 6 or 7 months, which has led to some fairly seismic changes in the commercial property market. So we've already seen over the past few years a significant contraction in the retail property market, and it seems likely to be a similar contraction in the office market over the next few years as working from home takes more of us out of the office and back into our home environment. So what does this all mean for dilapidations claims? Well, it seems to me that inevitably it will mean that there is likely to be a significant upturn in claims. And indeed, both Walker Morris and I know Paul at Radius have already seen this through an increase in instructions coming across our desks. So it was on the back of that that we thought that a session on dilapidations would be a timely one to roll out. Now, the assessment of dilapse liability is an incredibly important part of any property appraisal, and it's one that's often overlooked until lease expiry. I had a client some years ago who would renew every few years in a lease, not because they wanted the space, but because they didn't actually want to crystallise the dilapidations liability. And that's not a position or happy position really for any tenant to be in, because dilapidations liabilities can be substantial. And as tenant demand for space decreases, it seems to me that claims will inevitably increase. And it also seems highly probable that those claims will become harder fought as landlords look to offset rental voids by using dilapidations claims as a means of doing so. So hopefully in this webinar, we will offer you some helpful guidance, some tips as to how to manage those claims, both from a landlord and tenant perspective. We're going to cover 4 areas, which we can see on the slide here, and each of the participants will speak for roughly around 10 minutes on each of those areas. And then at the end of the session, we will hopefully have an opportunity to take some questions which you can post throughout the webinar using the Q&A function, which should hopefully be on your screens. And the view then is to wrap up by around about 1 p.m. Today. So first and foremost, I will then hand over to my colleague David Manda, who is going to wax lyrically on the subject of effectively managing lease end or terminal dilapidations, as we call it in the trade. So over to you, David.
Yeah, thanks, Martin. As Martin said, I'm going to discuss sort of managing terminal dilapidations, and that's both from a landlord and tenant's perspective. Before I sort of go into the different considerations for each of those parties, there's sort of a need to ensure that the parties have the relevant documentation and information required. And I've put on the slide there sort of what I think are sort of, I suppose, the important documents and information that need to be gathered and garnered at the outset of whenever one's looking at dilapidation. So, obvious one is lease, and that includes both superior and subleases. Any licenses for alterations or consent letters for anything that's been undertaken. Often, can be contentious area schedules of condition, not least because sometimes you find they're not actually kept safe and kept with the actual lease. You've got the layout plans, marketing information, obviously original specification against any alterations. Useful to have a schedule of fixtures and fittings. Understanding the VAT position of the parties as well, and whether the VAT is recoverable, etc. And I've put on there either landlord or tenant whether they intend to do any works, and I will sort of come on to that and touch on the importance of doing that. But I think that's an important aspect right from the outset to understand, for both aspects, what's not from a tenant's perspective, whether they're going to do any works, and from a landlord's perspective, what they intend to do with the property. So next slide, please, Jordan. The next point I want to touch on as well, and again, it is a general point, but applies perhaps more to landlords because of the consequences that I'll touch on. Obviously, it's usual for a lease to contain a covenant that sort of limits the tenant's ability to carry out alterations to the premises. And equally, it may obviously include a provision that those alterations can't be carried out without a licence of consent from the landlord. And that licence will often include an obligation to reinstate those alterations. I mean, from a landlord's perspective, I mean, if those alterations are of value to the landlord, I mean, one example can be an air conditioning system, for example. The landlord may want to may not want to rely or have those alterations reinstated at the end. Now, I've put some general clauses on there. The first point, there was a general reinstatement clause that you'd expect to see. Obviously, effectively, it places an obligation on the tenant to reinstate 6 months prior to the lease expiry. One other point I'd flag on reinstatement is that landlords need to be cautious about the obligation to reinstate on notice. This can be a bit of an administrative nightmare for landlords, because if the landlord fails to give that notice, then the tenant is not obliged to reinstate. And obviously, as I said there, it can be costly depending on what alterations have been made throughout the term. I mean, from a landlord's perspective, when negotiating the terms of the lease, the landlord will want to push back, in my view, on any notice requirements being a precondition of reinstatement being carried out. As I say, because of the potential consequences. Two other points I've raised on the slide, which often I get asked, is about whether there's a certain period of time required in terms of the notice, and I've put there only if it says so. Because actually, if it's silent on the timing of the notice, and equally this touches on the second point, is the question of whether notice. And again, short, the answer to that is no, which from a tenant's perspective, can be problematic, because obviously they may get a notice very close to lease expiry with insufficient time to carry out the works. So on to the next slide. The next slides sort of deal with a variety of different sort of tactical and practical steps, I suppose, that parties need to think about. First one is obviously from a landlord's perspective, serve the claim as soon as possible after lease expiry, and that seems obvious, but it's advantageous to do so, just so you can get the ball rolling. And I know Lewis will touch on the timeframes involved with dilapidations claim. Obtain credible and objective valuation advice. I mean, I've been acting for a tenant on behalf of a tenant who received a pretty extensive schedule of dilapidations with a very large figure for costs of works. Obviously, we, being the tenant, obtained our own advice and obviously responded to the schedule accordingly, and explaining that was actually an extremely optimistic figure for the landlord to claim. And the problem that I find with that sort of approach is that if the landlord produces, if you like, an unrealistic dilapidation schedule that's not credible, then what it leads to is just the process being elongated, and in turn simply incurs further costs and ultimately just delays payment to the landlord. So it can be a bit of a false economy to take that approach. From landlords, if it's feasible, undertake the necessary works. I mean, one of the great advantage to that, if the landlord does do that, it shifts the burden onto the tenant to show that the diminishing value is less than the cost of works, And I know Paul will touch on diminishing value issues later on in the seminar. I've put on there as well, make a well-pitched Part 36 offer in its early stage. And ultimately, this is an offer that says the landlord's prepared to accept a sum of money in settlement of the claim. And again, the advantage of that is that if it's well pitched, it increases the pressure on the tenant, in my view, to settle the claim, because the risks then lie with the tenant. And again, whilst that's a cost point, I know Lewis is going to touch on that a bit more later on. Check the cost recovery clause. Our landlords be aware, because often you find well-drafted leases will include a provision for a landlord to recover its legals and associated costs, really, from the tenant, and often these are included and set out in the schedule of dilapidations that's served anyway. And finally, and sometimes sort of often forgotten on dilapidations, I've asked the question, is there a guarantor, original tenant or former tenant that may be liable? And I think in the current economic climate, I mean, this can be particularly important, because if there's a guarantor or former tenant that may have some liability, especially where liquidation, administration or CVAs may be coming up and will be becoming more prevalent, obviously you sidestep the insolvent tenant, and the prospects of recovery obviously increase, but presuming they're obviously good for the money as well. So what about the tenant? So I've put a diagram there that hopefully the starting point is obviously at the top, and work your way from the right-hand side. But for the tenant, in my view, I think it starts before you even sign the lease. It's understanding, and obviously seeking legal advice on it, but understanding what the repairing liabilities are before you sign the lease. And it does need to be taken into account, and I think Martin touched on that in the introduction. Schedule of condition, again, from a tenant's perspective, especially for older buildings, etc., that have been rented out for long periods of time, whatever it may be. I think one thing is just ensuring they're kept with the lease, because I say often they do seem to get forgotten about, especially if it's particularly long term. Having systems in place, tenants having to sort of manage repairs, both that's during the term, but also prior to lease end. And I think for tenants carrying out a review, I would say 12 to 18 months out from lease expiry, it is a good time to work out what you're doing with the property generally. Are you staying going? And obviously reviewing the dilapidations, any potential dilapidations at that stage. I mean, from a tenant's perspective as well, if there's a clear breach of the repairing obligations, I've got to say the best legal advice is often to simply carry out the works if there's time to do so and funds to do so, etc. And these are often the works that the tenant surveyor would have pointed out if you've done that assessment and planned in advance. Again, benefits of doing that as well is, if the landlord then seeks to put in a rather inflated claim, then actually you may well be saving time and money, after the fact, i.e. after you've left the premises. Another advantage, I think, of carrying out an early assessment is not just in terms of the costs of works or doing any works, but in starting the dialogue early with a landlord. It ensures a smooth exit, but also from dilapidations perspective, you can try and find out what the landlord's intentions are for the property. Because if, for example, the landlord intends to redevelop or demolish, then some or all of the repairing obligations may well fall away. And again, the extent of any work may well be reduced or reduced to nil, depending on the circumstances. Tenants should also, it's not just a landlord consideration, but tenants should also get good valuation advice, because again, that valuation advice may well reduce any dilapidations claim. And off the back of that, you can consider making, again, sensible Part 36 offers where there is some liability. And from a tenant's perspective, that will put landlords under pressure to settle the claim from their end, especially if landlords are perhaps being slightly unrealistic in respect of their claims. Another point as well is, in terms of the discussions, you may well garner whether there's an appetite for landlords to get involved in litigation for a claim. And if you can put in certain procedural hurdles that, if you like, elongate the process, then that may reduce the landlord's appetite to pursue any claim further. The only final point I'll briefly touch on is a cost recovery point from a tenant's perspective, and that's linked to Part 36 offers as well, just in the sense of often, because the costs of the claim potentially can be recovered by the landlord, that's something the tenants need to be aware of from the outset. I'm now going to pass over to Lewis. Oh, sorry, back to Martin. Apologies. Back to Martin, who's going to talk about common areas of dispute.
Okay, thank you, David. As David said, I've got 10 minutes to talk to you about common areas of dispute in dilapidations claims. I think the first point to make is that relatively few dilapidations claims actually end up in court, or indeed anywhere near court. Most are resolved through negotiation and agreement. In my experience, there are a couple of reasons, however, that claims typically don't settle. And the first one is, I suppose, a philosophical point to some degree, but it's that I think that the landlord's aspirations have not been properly managed at the outset, because often at the outset the landlord will see a large cost of scheduled dilapidations, but that doesn't always translate into a correspondingly large loss and therefore large payment. So once the landlord has ever seen the initial cost of works figure, it can be then difficult for landlord to accept or calibrate down its aspirations that a lower sum is the appropriate measure of loss. Now, Paul will talk in his section about how cost and value are not the same thing, and how valuation issues play a critical, if not really, I think, fundamental part in fixing a dilapidations liability. So I don't want to step on his toes too much, but what I can say is, from the perspective of the person who deals with the dispute resolution, that disputes can and often do arise, I think, when the landlord team loses or perhaps has lost sight of the fact that dilapidations claims are fundamentally compensatory in nature. They're not designed to provide the landlord with a windfall. Now, the second reason there are disputes is because one or more legal points of interpretation crop up in the lease, and there can be a myriad of reasons why those disputes might arise. But I'll take you through on the next few slides some typical areas where conflicts might arise and where we have seen sort of disputes arise over the years. So the first slide you'll see there is, the question is, well, what's the subject matter of the covenant? What is the thing that needs to be put into repair? And that's the subject matter of the covenant is obviously the premises. You'll see there that there's an initial definition of premises. Those will be premises in the context of an FRI lease. Well, what is an FRI lease? I'm sure that most of you will be cognizant of the fact that an FRI lease is a full repairing and insuring lease. So the tenant is responsible for essentially the whole kit and caboodle in relation to the building, so the structure, the exterior, the common parts, the M&E, which often is a big ticket item in relation to any dilapidations claim. Now, what you'll tend to find is that an FRI lease will produce a far larger liability than a corresponding internal demise only lease of the same building, because in an internal demise only lease, the tenant is only responsible for the fabric of the unit, and it doesn't assume responsibility for the structure, the exterior, the common parts. You do have to obviously factor in that in an internal demise only, there's probably going to be a service charge obligation, and therefore then the tenant may get stung for dilapidations for the exterior and common parts, etc. through that. So in terms of how do you construe what the premises are, well, it's a question of construction, of the obligation, the context of the lease as a whole, taking account of the surrounding circumstances, as we say in sort of legal terms, a factual matrix that exists. And disputes arise really where there's lack of clarity in the drafting, in the definition of premises, and that really is the lawyer's job to make sure that there's clarity in drafting, assuming, of course, the lawyer gets clear and unambiguous instructions from his client. So that's premises. So moving on to the next slide, please, Jordan. So standard of repair. So this is quite an interesting area. There's no uniform standard of repair. That's the first point to make. It's a fairly fluid concept. And the standard and nature of the works to be carried out depends on the age of the property, the nature of the property, when the term begins. It also depends on the locality of the property. That's fairly critical. So You can see there two examples. You've got a brand spanking new office building there in Canary Wharf, and you've got some fairly sort of aged offices in Bradford. And those two properties are going to produce very different standards of repair, because when you're assessing the standard of repair, you've got to look at it, the building as being fit for occupation of the reasonably minded tenant of the class likely to take them. So the building at Canary Wharf might be the head office of JP Morgan. The offices in Bradford more likely, to be a building that houses, say for example, Joe Bloggs Limited or something of that ilk. So very different premises, very different buildings, very different tenants, and hence, critically, very different standards of repair. Another important principle is that, again, in terms of the Bradford property, if it's old, there's no obligation to modernise. There's no obligation to bring the Bradford property up to the same standard of repair as the Canary Wharf property, because you're comparing apples and pears there, really. But our job as solicitors, I suppose, and also building surveyors, is to determine whether or not works, do they go beyond repair? Now, this is a fact and degree test. You've got to look at the building, you've got to look at the date of the lease, you've got to look at the precise terms of the lease. And then you've got to conclude, and this really is a sort of judgment call, whether on a fair interpretation of terms and respect that relate to the state of the works, can the works fairly be termed repair? And a critical point and I suppose a fertile ground for dispute is inherent defects, because inherent defects will sit outside the scope of the repairing obligation. So we have a dispute on at the moment, we're acting for the tenant. The building is one that doesn't have any wall ties, bizarrely enough. So the exterior skin of the building is liable to collapse. It is defective because of the absence of wall ties. So we as tenants say, well, the absence of wall ties is an inherent defect, and therefore it sits outside our repairing obligation. The landlord, unsurprisingly, says otherwise. But that's a big cost. That's a sort of £1 million plus cost that we're talking about there. So it's these sorts of points around inherent defects, and particularly in the context of shopping centres as well, can be sort of big ticket items, and therefore they can be a sort of fertile ground for dispute between the parties. On the next slide, I've set out some typical standard repairing obligations. I mean, the repairing obligation is fairly standard across most leases. There's some nuances to it. The important point in relation to the first covenant is that the landlord's obligation, the tenant's obligation to keep in repair. Now, to keep means to put in repair. Now, that's a distinction that will be appreciated by most sophisticated landlord clients. It'll be appreciated by most sophisticated tenant occupiers, but not by all. But it's absolutely critical to appreciate that the tenant will inherit historic disrepair under this clause, absent a schedule of condition. And we'll come on to talk about schedules of condition a little bit later. Now, the second covenant I've cited there, if you look at the adjectives good and substantial, that's not perfect. So it's not pristine, it's not an absolutely perfect A1 standard of repair. It's good, it's substantial. So often we see these schedule of dilapidations which deal sort of ad nauseum with every single item, every single scuff mark on the premises, but just because the skirting boards are scuffed doesn't mean to say they're in disrepair. The third covenant is a repairing obligation qualified by a schedule of condition, and in the next slide we'll talk about the applicability of those and the suitability of schedule of condition and how they can assist in at least ameliorating the tenant's responsibility for historic disrepair. The final point I just make on this slide is that the covenants I talked about there are express obligations. There, of course, can be implied obligations as well. So as a tenant, if you have a periodic tenancy, just because you don't have an express obligation in it, whether it's written or oral, doesn't mean to say that you won't have an implied obligation, the duty of tenant-like user or the duty not to commit waste. And then moving on to the next slide, schedule of condition. So these can be a fertile ground for dispute. I posed the question there, well, burden of proof in the case of a poorly prepared schedule, where does it sit? And I think the reality is it's more of a problem for the tenant than it is for the landlord. The landlord has the covenant. the tenant is seeking to qualify the covenant by reference to the schedule of condition. And these documents are open to interpretation. We see a fair few of them. They range from being terrible to very good. The more ambiguous they are, the more scope for dispute, the more problems for tenants. So they're not necessarily a panacea to the tenant in terms of removing any historic liability it may have. I've given a couple of examples there as to how they're open to interpretation. So you'll see there, you've got the Tower of Pisa. The landlord will say, well, it wasn't leaning when I granted you the lease, and therefore then you've got to put it back in an upright condition. The tenant will say, well, actually, no, it was leaning when I took the lease, and therefore then I'm absolved of that obligation. On the next slide, you actually see a more down-to-earth, real-world example. And you can see there you've got the same photograph, but two very different interpretations. The landlord's view is, well, it was free from defects. The gutter is free-flowing. There were no issues with it at all. The tenant takes a different view. It says, well, actually, hang on a minute. The valley gutter was already showing widespread corrosion. There were missing fixings and caps, and the waterproof membrane is severely deteriorated. So these documents are open to interpretation, and they need to be as comprehensive as possible. You should consider a written narrative, or certainly ask the building surveyor who's producing them to consider a written narrative if appropriate and if necessary. They're not a panacea, as I said, to absolving the tenant of historic liability, but they're the best solution, frankly. And therefore then, in the appropriate circumstances, they will be used. And I suspect probably as the property market does contract, then schedules of condition will be used more often, because tenants are just not going to be prepared to take on an FOI responsibility in the context of a building which is already materially dilapidated. Moving on to the next slide swiftly. So, is there disrepair? Well, without disrepair, there is no claim. It sounds rather obvious, but there's plenty of case law where this point has been debated. And I've given an authority there for Quick against Tough Eli, which basically does what it says on the tin. It requires repairing a condition worse than it was at some earlier time. So unless there is deterioration, the fact that the building might, for example, be unsuitable for occupation is irrelevant to liability under the covenant to repair. So that example I've given there is in the landlord context. So the landlord's got a covenant to repair, but the building is unsuitable for occupation. Then, unless the landlord's in breach of its obligation to put the property into repair, there will be no claim. There might be a claim in a different context, but not in relation to the repairing obligation. And then moving on to my final slide, I've set out what is a fairly well-trodden 5-part analysis, but it's a really useful guide, I think, to follow for landlord and tenant alike in terms of sort of assessing whether or not there are breaches of covenant. So the first question you ask yourself is, well, what's the subject matter of the covenant? And we talked earlier about the distinction between an FRI lease and internal demise only. The next question, is the subject matter damaged or deteriorated? There has to be deterioration, question of fact. The third question, is the condition below the standard contemplated? See, for example, the distinction between the Canary Wharf property and the Bradford property. It's not a uniform standard. The fourth question is, well, what work is necessary to put the property back into the condition contemplated? This is where you do get a fair amount of conjecture, probably the most conjecture you get on a sort of cost of works analysis. The distinction between repair, replacement, for example, in the case of a roof that leaks, the tenant says, well, look, I'm just going to patch repair it. The landlord says, well, no, hang on a minute, you have to replace the whole roof. But where there are several options in terms of putting the property back into repair, the tenant can choose the most cost-effective option. It's not permissible for the landlord to say, well, no, hang on a minute, you've got to choose the most expensive. It's not the way it works. It's the tenant's choice, essentially. And then the final question posed is, did the parties contemplate the work with the liability of the tenant? Again, here, question of fact and degree, but more particularly consider inherent defects. And the final point I just want to make, which I suspect is probably a point that all the lawyers are going to make, is just about costs. That another area of dispute, another impediment to settlement is costs. Now, any well-drafted lease will contain a tenant indemnity to the landlord in respect of costs, and that's a really powerful weapon in the landlord's armoury. And it means that in the absence of a early pitch Part 36 offer, as David said in his segment, the parties are going to be negotiating or litigating the tenant's expense. So I think if anybody who on the webinar is listening to the tenant side of things, I think that is an incredibly important point to take away, because you don't want to end up, with £100,000 liability on the cost of works with a £40,000 bill in terms of landlord's costs, and that is something which means that an early assessment of your liability is absolutely critical in any dilapidations claim. So that is me done. So I will then hand over to Paul, who is going to talk to you about how much should a tenant be obliged to pay for disrepair at the end of the lease. So over to you, Paul.
Thank you very much, Martin. So I'm a valuation surveyor. The other type of surveyor, the other discipline of surveyor, required to optimise outcomes in dilapidations claims for both landlords and tenants. So I know there are building surveyors watching this, so forgive my rather brief but nonetheless respectful account of the distinction between us. The building surveyor, the expertise of the building surveyor, of course, lies in identifying breaches of covenants to repair, redecorate and reinstate, to price the remedies, and therefore it's the building surveyor who prepares the schedule of dilapidations or quantified demand. As part of that, of course, because building surveyors quite rightly front the dilapidations process, there is an expectation that the building surveyor will advise if and to what extent diminution in value, or Section 18, might play a part in the dilapidations process. And of course, the building surveyor, with all respect, isn't qualified in valuation. That's where the valuation surveyor comes in. So both surveyors are in fact required, but seldom end up actually working together from the outset. So there is a disconnect, which can create a problem for both landlords in terms of inflating expectations as to where the dilapidations might settle, and also problems for tenants if diminution in value isn't used at all or isn't used properly in terms of over-settlement. What I'm talking about, of course, refers to the what's colloquially called the dilapidations cap. So in England and Wales, we refer to Section 18(1) of the Landlord and Tenant Act 1927, which provides a cap as to repairs, damages for breach repairing obligations. Similar common law applies to both redecorations and reinstatement, and that cap being that the quantum of damages will be the lower of the cost of the remedial works or the impact upon the property's value. And almost invariably, for most second-hand commercial and leisure properties, the impact on value is, in our experience, considerably less than the lowest costed assessment of the remedial works. Cost and value are not one and the same thing, although the terms are often carelessly transposed. The law of diminishing returns invariably applies, so that there is a point reached in objectively targeted remedial expenditure, beyond which spending can continue in pursuit of perfect compliance, but no more will be added to or recovered in the property's reversionary value. For those of you with experience of diminution valuations, you'll appreciate that there is a common expectation that the valuer will produce two valuations. Firstly, valuation A, assuming the property, that's A for alpha, by the way, my accent perhaps doesn't help. So valuation A, the property in assumed repair, assumed compliance, that's straightforward enough for valuers to do, because that's FRI comparables, resulting in directly comparable evidence to find the property in repair. Valuation B, the property in disrepair. It's actually an impossibility, really, to do independent of valuation A, because if you think about it, your comparables would not only need to be of similar properties in similar locations, they would also need to be suffering from much the same breaches or defects as to repair, redecoration and reinstatement. Almost impossible to find that. You probably have a greater chance of success with a contact tracing app, perhaps. So the practice that has emerged and evolved over the years is that the valuer produces valuation A in repair and then makes a series of deductions from that, primarily the cost of repairs and perhaps assumed loss of rent as well, to result in valuation B. Valuation B is then deducted from valuation A to magically reveal the apparent diminution in value. But if you think about it, that figure is the sum you've just deducted from valuation A to get to valuation B. So it's a long-winded and exaggerated process, which perhaps is why diminution valuations have become known as the dark art, this wonderful-looking spreadsheet of complex valuations, when in reality, all that really distills out of it and all that really matters is a more detailed analysis of the deductions which relate primarily to the repairs. Because not all remedies, not all breaches impact a property's reversionary value. Thus, there are really two filters, if you like, that the valuer should be applying to the building surveyor's costage schedule. The first one is in terms of supersession, a term you'll no doubt be familiar with. Supersession refers to items which, whilst genuine breaches with costage remedies, will be destroyed or overridden by works to, in the modern context, to use the modern term, repurpose the property. So to modernise, upgrade, and in fact often significantly change the property for its new life, its new market going forwards, to optimise its marketability. So to put that in the context of some examples in the real world, high street shop of 4,500 square feet, obviously was once a de rigueur size and in demand by fashion retailers through the 80s and 90s and early noughties. Virtually no demand for a shop of that size in any location these days. And of course, its upper floors that were once used for storage aren't used for storage anymore. Little stock held on site. And in the recent changes to planning, to ease the planning process, more scope for redeveloping upper floors for residential. So in splitting the ground floor shop into smaller units that might be more marketable, upper floors to either redundant and vacant, OTOs, or converted to residential, a lot of supersession can be foreseen there. Industrial and warehousing premises, very much in demand, all the more so with people home shopping through lockdown. But to get the best covenant on at the best rent for the most secure longest term with minimal or no schedule of condition, it needs to be presented very well with modern kit, modern M&E, brand new dock levelers, offices upgraded to grade A type specification. So again, a lot of supersession can be seen there. Offices, well, if we look pre-pandemic, if offices fell vacant that had been leased out for 15 to 20 years, if you just did the works purely as claimed in the schedule, you'd still end up with something that you would struggle to re-let because it's going to have many features and functions that are outmoded and require modernising to better present and best present the property. So you can foresee that level of repurposing accelerating in the pandemic world with more extreme examples to, without being that far-fetched, a stretch of the imagination, cinemas, former M&S Simply Food or Next unit on a retail park being repurposed altogether to perhaps a last-mile distribution point for a third-party logistics operator for Amazon. So it's the valuer's role to know the market and to reasonably predict, if you like, and to reasonably argue what level of supersession is likely in the case of the particular property. The second filter is to remove items which are not value effective. Not every breach affects every property in every location, and Martin covered quite a bit of this just now with his example about the property in Bradford versus the property in London. So it's very much an objective judgment by the valuer based on open market transacting experience, each case on its own merits, and it relates to the age, character and locality of the property. So it's another very simple example. If we had, say, a 20,000 square foot warehouse building, one of those is 40 to 50 years old, low eave height, corrugated asbestos roof. The expectations of that property, in other words, what the open market would expect of it and accept from it, are lower than they are for its modern 5-year-old equivalent, as I'm sure you'll appreciate. So to move on to some case study examples to hopefully better illustrate these points. First of all, we have some offices here in Chesterfield. This was actually a case for landlord. I should therefore point out at this point that tenant biased though diminution in value can sound, there are many situations where landlords of course require them. I mentioned earlier, perhaps useful from the outset to be involved with the building surveyor so as to better manage landlords' expectations. An inflated expectation never really wins points ultimately. Also to rebut opportunistic diminution valuations from tenants, as in this case. So the tenant had argued against the common law claim at nearly £600,000, as you can see. They had argued and advanced a diminution valuation suggesting the loss was in fact only £60,000 because the offices were going to be repurposed as residential. Utter bunkum, and in fact in the market as it was then, back in the good old days a couple of years ago, offices in this location were still very much relettable and they didn't need to be modernised significantly. So some modest modernisation, hence the settlement at very close to our diminution valuation. It's still well over £500,000. The next one is offices again, but for tenant and in London. And this was an example I touched on earlier on. The offices had been occupied for 15 years. My point being that even if they'd been vacated in perfect compliance, they would have been all but unlettable because everything was brown, dated, required modernisation. So notwithstanding the landlord's vociferous protestations to the contrary, we successfully argued that to modernise it to the form and style that it needed to be in to maximise its lettability would unavoidably involve a lot of supersession, and therefore the claim was significantly reduced by virtue of our diminution valuation. The next one is high street retail. A town like many around the UK decimated in recent years as to its retailing fortunes. Of course, that accelerates all the more in the pandemic world. So in this case, plenty of upper floors, not likely to be used again for storage. So they're either fallow and valueless in any event. They only need to be wind and watertight, far from immaculate, and may ultimately be converted to residential. As to the ground floor, I mentioned earlier the splitting of large retail units to meet modern demand for smaller units. There's also a different scenario like this one here, where in many towns, the only likely tenant you're going to get is an independent trader with no real income, certainly no capital to fit out a unit. So actually by not reinstating it, by leaving the tenant's shop fit in place, it actually has its best and only chance of reletting at all. So those are the kind of arguments that reduced, arguments or if you like, real world observations from open market agency experience that reduced the claim in that case. Then last of all, the example we have is, it's often said that when a landlord's done the works, they've proven their loss is crystallised, and I'm sure you've heard that many times. Our argument in response in such situations is the loss isn't proven. All that's proven is what the landlord chose to spend. So did they spend wisely? In this case, they had spent £2.2 million, and this had been absolutely proven and demonstrated to our colleagues as building surveyors on it. And the claim was then rounded up to £3.5 million, if you like, by throwing in £1.3 million loss of rent. And at this point, I should briefly touch on loss of rent. Often claimed, seldom succeeds. The reality is that the burden of proof does rest with the landlord to be able to evidence that on the balance of probabilities, the property would have readily relet had it been vacated in compliance. However, if there are other factors which would have delayed its reletting, which are nothing to do with dilapidations, so either market forces, a weak market at the time, and or landlords' modernisation, upgrading and repurposing works having to be carried out that could have run in tandem with the dilapidations works, then the loss of rent element will probably fail, as it did here, but only in the mediation. Live mediations have returned in our relaxation from lockdown, however long that may last, but nonetheless quite tough, as this was in Birmingham in 22 degrees with a face mask on all day. So the landlord's team clearly sweated the most and therefore capitulated the most, because in terms of cost of works, they had spent 2.2 million. Our arguments were that the lily had been gilded, so they had gone beyond the point at which the law of diminishing returns kicks in. Points that I made earlier on in this wee seminar, that not all costs relate to value. You reach a point in objectively targeted expenditure beyond which you're adding no more to value. Hence the settlement, £1.55 million. So in conclusion, what you've hopefully learned so far is that for optimum performance in dilapidations claims and optimum outcomes for both landlords and tenants, you need a good building surveyor, a good valuation surveyor, and a good lawyer. Wouldn't it be wonderful if you could get all three under one roof? So I'll hand over now to Lewis for his part again. Thank you.
So I'm going to finish off today's talk with an overview of the dilapidations protocol. The protocol sets out the conduct and the process that the court expects both the landlord and the tenant to follow prior to the commencement of court proceedings for claims for damages following termination of the tenancy. And so the protocol should be at the forefront of the landlord's mind before embarking upon a dilapidations claim, and at the forefront of a tenant's mind when faced with a claim. The protocol can be accessed from the court's website, and I'll provide a link to that when we circulate a note afterwards. I don't intend, you'll also be pleased to hear, to go through the protocol paragraph by paragraph. Instead, I'm going to focus on what I think to be the four key issues, which are the timetable that the protocol expects the parties to follow, what happens when there's non-compliance with the protocol, alternative dispute resolution and how that can be used as a powerful tool, and finally costs. Who's going to pay the legal fees and the surveyor's costs? An important question that I thought I'd leave you hanging on until the end to keep you watching. So in terms of the timetable, the various protocols that the civil procedure rules have adopted, for example, the protocol for debt claims, protocol for housing disrepair claims, and one for dilapidations. The protocols are not mandatory, but as I'll discuss in a bit more detail later on, there are sanctions for a party that fails to engage with the protocol. Attached to the protocol, and I've set out on the slide there, is sort of the process which the parties are expected to follow. It's very self-explanatory, and I expect that many of you may already be aware of the expected process and timescales laid out. However, just running through that flowchart quickly, it starts with the landlord serving the schedule of dilapidations together with a quantified demand, the schedule setting out the alleged breaches, the works to be done, and the costings. The quantified demand setting out the monetary claim that's the monetary sum that's sought. There are template schedules attached to the protocol, but there's no prescribed format for the quantified demand to take. The tenant ought then to respond within 56 days. Again, there's no prescribed format for the response, but the tenant's response usually takes the format of a Scott schedule that responds item by item to the landlord schedule. The response may also pick up some of the separate points about the level of damages, some of the points which Paul's picked up on in relation to valuations. There's then the opportunity for the parties to then take stock, negotiate, and come to some form of agreement. As Martin's mentioned earlier, a good proportion of claims will settle at this point, and rarely do matters get to court, and rarely do matters get to a final trial. If a settlement's reached, then the parties would be well advised to document the compromise in some form of settlement agreement so there's no ambiguity. Then if settlement isn't reached, then it is for the landlord to then issue a claim at court. So what happens if the parties ignore the protocol entirely or deviate from the process laid out in the protocol? If there's non-compliance, and just sort of moving on to the next slide. The protocol, as I say, is not mandatory, and the failure to follow the protocol does not prevent a landlord from issuing a claim at court. However, there can be two key consequences for parties not engaging with the protocol. The first is that the court may impose cost sanctions for non-compliant parties. For example, if a landlord prematurely issues the claim and wins at trial, the court may order that, as the landlord did not comply with the protocol, some of its entitlement to costs are reduced. Secondly, I recently acted on behalf of a tenant who recently faced a claim that had been issued where the landlord had entirely ignored the protocol and just issued the claim straight away. As such, we issued an application to stay or pause those court proceedings to require the landlord to engage with the protocol, and the court granted that order. This then puts the landlord on the back foot, and in the deal that was ultimately done, the landlord ended up paying the court issue fee. So the advice is to always actively engage with the protocol. Having said that, on the flip side, you do come across some advisors who, usually acting on behalf of tenants, will try to abuse the protocol to try and frustrate matters and try to drag the process out. The court will usually take a pragmatic approach, and so long as the parties have shown that they're acted in the spirit of the protocol, the court is not going to be too concerned with minor shortcomings here and there. So moving on to sort of ADR, Alternative Dispute Resolution, ADR. As I've set out on the slide, the court takes the view that litigation should be the last resort, and the protocol encourages the parties to try and resolve the claim without having to issue court proceedings. ADR can take many forms: mediation, arbitration, expert determination, or just simple negotiation. The most appropriate form of ADR will depend on the value of the claim, the complexity of the issues, and how stubborn or difficult the parties are being. For example, it may be disproportionate to have a full-blown, full-day trial in a modest dilapidations case where the cost of the mediation may outweigh the value of the claim. However, it may be suitable to have some form of mediation or some form of early third-party determination in a high-value, complex dispute. However, what can be a powerful tool, and sort of lawyers have already picked up on already, is about making a well-pitched Part 36 offer. In simple terms, as has been explained before, is that this is an offer that complies with Part 36 of the Civil Procedure Rules. If it's made by a tenant, it sets out that the tenant will pay a sum of money together with the landlord's costs up to the date of the offer and 21 days thereafter. The benefit, especially for the tenant in making that Part 36 offer, is because almost always the tenant is going to be having to pay the landlord something, and so the landlord will be perceived to be the winner if proceedings do reach a final trial. With the usual rule in litigation being that the loser will pay the winner's costs, this means it's usually always upon the tenant who will be footing the costs for the bill. However, if we have a claim where the landlord is claiming, for example, £500,000 and the tenant has made a Part 36 offer of, say, £300,000, and at trial the judge awards the landlord less than 300, let's just say for this example £100,000, then what Part 36 of the Civil Procedure Rules says is that as the landlord has not beaten that Part 36 offer, the landlord has to foot the bill for the parties' costs, both parties' costs, from the date 21 days after that offer was made. As such, and as everyone said to date, if an early Part 36 offer is made, then that the tenant can be confident it will be beaten. Then if the landlord then continues on to litigate, the tenant will have a degree of comfort that the parties will be litigating at the landlord's costs rather than at the tenant's costs. But there are also some benefits for the landlord to make a Part 36 offer. This will be where the landlord says he'll accept a sum of money in settlement, and if the landlord at trial beats that offer, then the landlord will be entitled to an enhanced level of interest, indemnity costs, and a bonus payment of up to 10% of those damages. What I'd stress though is that a Part 36 offer has to be well pitched. If the offer does not strike any fear in the opponent and that it won't be beaten at court, then at best it will be seen as being an opening bid. For the tenant, a badly pitched Part 36 offer will not provide any beneficial cost protection. So then finally, what about costs? Typically, as Martin picked up on earlier, most modern leases will include an obligation on the tenant to pay the landlord's costs of preparing and serving the scheduled dilapidation and enforcement of any tenant covenants in the lease. I've set out there a couple of example cost provisions that you'd expect to see. And then, so accordingly, the starting point is that the tenant's going to be on the hook for the landlord's costs in a dilapidations claim. Again, it's for this very reason that it's on the tenant to actively start thinking from the very outset about making that well-pitched offer of settlement or engaging in some form of ADR. If the claim does reach a final trial, and I said this is fairly rare, the court does have discretion as to the level of costs to be paid by one party to another. The court will look at first, what does the lease say about who pays the costs and on what basis? Secondly, the court will also look at whether the landlord has been wholly successful or only successful in part. Thirdly, the court will look at whether or not how the parties have conducted themselves. For example, did the parties comply with the protocol? And finally, the court will consider any offers of settlement and whether those offers have been beaten. So then, in summary, I hope that provides sort of a helpful overview of what the Dilapidations Protocol says. But in summary, the takeaway points are: one, there is a timetable provided for within the protocol that the courts expect the parties to follow. Two, prematurely issuing court proceedings and ignoring the protocol may come with sanctions. And finally, whichever side of the fence you sat on, landlord or tenant, do actively consider settlement at an early stage, and doing so may save you a considerable amount of costs later down the line, even if you're the perceived winner. So that sort of draws an end to the talk, and I'm going to pass across to my colleague Jordan to see if we had any questions. If we don't have the opportunity to answer all your questions now, then we will pick them up in the note that follows, or if you think of any questions that come to mind afterwards, then feel free to get in contact with any of us. So thank you.
Thanks all. Yeah, we've had a few questions come through, so I'll kind of run through those quickly. The first of which is, whose responsibility is it to prepare the Section 18 valuation, and is that something that should be done by the landlord at the outset when they serve the schedule?
That's probably for me to answer, but there'll be legal input on this as well, I'm sure. As will have been gathered from points I was making at the outset of my piece, I think for landlords, there are two reasons to consider early use of obtaining a diminution valuation. One, to manage expectations. I think no landlord's going to thank you for a common law assessment which is grossly in excess of where it's likely to end up once diminution in value is applied to it. So if nothing else, to have in the back pocket even, in order to manage expectations as to where it will end up. And then secondly, of course, when I know you were covering the protocol just now, Lewis, and you couldn't cover it all. When landlords are not doing the works, which is increasingly the case I find these days, both because of rental starvation suffered during lockdown, and because so cash flow issues there, and because the repurposing of the property, the new life of the property is as yet unclear, then the works aren't being done. And paragraph 9.4 of the protocol, of course, requires a landlord to produce a diminution valuation to evidence loss. So there are genuine situations where, and perhaps all the more common than might be imagined, where landlords should be considering and should be obtaining diminution valuations very early on in the process. I hope that answers the question from a valuation perspective.
I think from a legal perspective, then I think, Paul, the point you highlight there is very salient, that if the works have been done, then it's generally established or accepted that the cost of works is the best evidence of loss. So I suppose the value in the report is perhaps less so. But I think if a landlord hasn't done the work, and as Paul says, typically the landlord won't have done the work, certainly put it at that early stage, then I would remind you just to get on and get the report done, because unless and until you get that report done, you can't legitimately issue legal proceedings. You then have a better idea as to what the actual loss is relative to the cost of works. And as I touched on in my intro, that I think that then brings a dollop of realism to the claim, whereas you can spend a lot of time obsessing over the cost of works figure, but when you actually look at it from a valuation perspective, you realise that the actual loss can be significantly lower than the cost of works figure.
Okay. You do often find you don't get one though, don't you? They'll just simply then they claim. If you, David and Master, have a similar experience.
Sorry, I missed that, Lewis, actually.
Yeah. You often do find that landlords don't serve with their claim. They'll typically prepare a schedule and they then look to issue the claim.
Yeah, you do, but I suppose what you may find as a litigant then is that if you issue without a report, if I was acting for the tenant, I would then apply to court to stay the proceedings pending compliance with the protocol, and then you potentially end up on the end of a significant cost bill for that application to stay the proceedings. So I think it would be a courageous landlord who issued proceedings without first having served his report, because I think a well-advised tenant will be able to stop him in his tracks.
Yep.
Yeah, forearmed is forewarned.
Yeah. Okay.
Yeah, and then moving on to next question. Can all the fees associated with a delapse claim be recovered from the tenant? So solicitors' fees, valuers' fees for preparing the Section 18 valuation, for example?
But I suppose that will depend on the cost indemnity in the lease. Even if you have a cost indemnity, it doesn't necessarily equate to 100% recovery. It may well equate to something not far off 100% recovery. So even if you don't have a cost recovery clause in the lease, if proceedings are issued and you are successful in those proceedings and you beat any Part 36 offers, then costs will be recoverable as costs of the proceedings. But typically speaking, those costs on assessment work on the basis that you would recover, say, around 70, maybe 75% of the total costs incurred. I mean, obviously, if those costs are totally unreasonable, then the level of recovery is going to be correspondingly smaller. But if you've got a well-worded cost indemnity in a lease and you're not on the end of a successful Part 36 offer from the tenant, then you as landlord can expect to recover the overwhelming majority of the costs that have been incurred. But really, it's one for the lawyers to check the cost indemnity to see what it covers and make sure it's comprehensive enough. And I suppose just the final point I'll make on that is that those costs will sit outside the valuation. So even if you've got a diminution in value, say, of 200,000, those costs are contractual costs, so they will not sit within the Section 18 cap that Paul talked about. Okay. I think we've just gone over 1 o'clock, so I was intending to sort of wrap things up there. I think it's been great that we've had so many acceptances for this webinar, which perhaps shows that it was a timely webinar to run. And if anybody does want to sort of have any further advice or discussion on other questions, then please feel free to get in touch. And I think, as we said, we will circulate a note to everybody summarising what has been covered in this webinar and with some contact details. So, and we will be running further sessions in the future. So, hope to see you at those sessions. So, thanks very much for attending, everybody.